Krishna Kumar garu, senior advocate, and Sri Damashankar garu. So with respect to your question, in IBC most of the cases we have dealt with financial creditors, several financial creditors. Financial creditors never ask us whether we should go for a mediation or arbitration, because they have their provision to do a one-time settlement if the borrower approaches them. So in financial creditors, definitely no, they never talk about the mediation or arbitrations. But operational creditors, definitely they may look at the mediation or arbitration. But the problem of either a mediation or arbitration with respect to the operational creditor is in a different form. So in IBC, we file three types of applications: Section 7 application by financial creditors, Section 9 application by the operational creditor, Section 10 application by the corporate debtor himself. Section 7, the several events were happening, and earlier, prior to the IBC, we have the corporate restructuring mechanism, CDR mechanism, where borrower and all the lenders used to sit and have a corporate restructuring agreement, but that mechanism has failed. So that is why now we have moved into the IBC regime. In operational creditor cases, one of the prerequisite for admitting of any application to the CARP is that there is no dispute. The moment you suggest to anybody, operational creditor, that let us go to a mediation or arbitration, that proceedings will give a flavor to the adjudicating authority. There is a pre-dispute in the matter. The moment you are giving that presumption of pre-dispute, also there are chances of not admitting your case. So therefore, even Section 9 application, if anybody come and ask us also, we suggest that let us not go to the arbitration if you wanted to get into the CARP. CARP is more pressure, putting more pressure than going into the arbitration. So that is, but recently the IBBA has issued a notification, discussion paper was issued on November 4th of this month, and they are asking suggestions from the general public, and time is there till 24th. And they have suggested a model regulation to be inserted in the CARP regulations. The model regulation, there are several debates are happening right now. The model regulation, again, they drafted like this: an operational creditor may undergo mediation with the corporate debtor for resolving the disputes. I am stressing this: resolving the disputes of commercial nature in accordance with the provisions of the Mediation Act 2023 before filing the application under Section 9, and thereafter file application under Section 9 along with the report of the mediator. So in this regulation, they are making it is not a mandatory, they are giving the liberty to the operational creditor to go before the mediator. But again, here the issue is that they say that the disputes in a commercial matter. The moment you say that dispute, the operational creditors are not interested to go to the mediation. So the suggestion to the IBBA to remove the dispute and commercial nature, instead of that, simply say that go to the mediation. If the mediation fails, then come back, you can go ahead and file a petition before the NCLT. And again, the another issue is that again, IBC is a time-bound manner. But again, if the mediation is conducted under the Mediation Act, again 120 days plus 60 days, again it will take 180 days. Again, you have to spend time of 180 days in the mediation. Then again go to the NCLT, and NCLT will take its own sweet time. So these are the two aspects, and they also have to consider that if the as and when the mediation fails, they are not required to wait for that. The party should be allowed to file application in the settlement. So this clause of the